Sorry to keep you waiting. Didn't do a show yesterday. I overslept. I wish I had a better excuse other than I didn't wake up till late in the afternoon. Donald Trump goes 1-3 before the Supreme Court today. He won one decision, lost three. So we have some late-breaking decisions from the Supreme Court that possible nightmare scenario for Donald Trump. It's one of the reasons he knows he can't ever step foot out of the White House. And it's why he's doing whatever it takes, essentially, to never leave. Never leave. The Supreme Court on Monday refused to hear Donald Trump's appeal on that $5 million judgment against him in the E. Jean Carroll civil lawsuit. This is huge, a little complicated, and there are other decisions I want to get to. This is the home stretch for the Supreme Court. Tomorrow, supposedly, is when they offer up their last batch of rulings. Stick with me on this because I'll go over all these decisions and it'll be easy for you to understand. I promise you, I make Supreme Court decisions very easy to, an idiot can understand it. This is why Donald Trump watches my show. Okay, this E. Jean Carroll decision is one of about four that came down on Monday. Trump won one, lost three. The E. Jean Carroll trial is much bigger than a lot of people realize. And again, it's one of the reasons he's never going to leave office in 2029, because this decision helps open the floodgates for Donald Trump to spend the rest of his miserable, pathetic turd of a life in civil court if and when he ever leaves office. Partly, not entirely, but partly because of Monday's decision by the Supreme Court not to hear Donald Trump's appeal. Partly because of this decision, if Donald Trump leaves office, he's looking at a life where every year will be a replay of 2024 without that last-minute Hail Mary of trying to win the presidency. And that worked out for him. Had he not won the presidency, he'd be, I don't know if he'd be in prison, he'd just be spending the rest of his life in court. Do you remember 2024? Do you remember? It was 2 years ago. This is what 2029 and every year after that will be like for Trump should he leave the Oval Office. It will be 2024 every year for the rest of his life once he leaves, or if he leaves in 2029. Do you remember 2024? He lost two civil lawsuits, the E. Jean Carroll lawsuit, where he was ordered to pay her close with interest. I think it's up to $90 million now. And he also lost the civil lawsuit filed by New York State Attorney General Letitia James, where he was found civilly liable for ripping off banks and lenders to the tune of $500 million. He was ordered to pay a fine of $500 million, which he didn't have. That fine got overturned later by the New York State Supreme Court. Letitia James, the state attorney general, is reportedly appealing that decision, but the judge's ruling still stands that Donald Trump defrauded banks and lenders out of hundreds and hundreds of millions of dollars. That decision and the E. Jean Carroll decision all came down in 2024, as did the Manhattan hush money conviction, that trial in May of 2024. Donald Trump became a convicted felon, and no matter how hard he tries to appeal, it won't get tossed out. 2024 also was the year of the Georgia RICO indictments, which went to trial, not his trial. 4 people pled guilty. It eventually got thrown out because the prosecutor who eventually took over the case, a Republican, said, Georgia lacks the resources to try and convict a sitting president. He wasn't found innocent. They just said he's the president and we're not going to prosecute him. He did rack up huge bills in 2024 trying to delay that trial. And let's not forget, that was the trial that gave us this, his mug shot. He was never cleared in the Georgia RICO trial. He won the presidency, so he wasn't put on trial, okay? And then there were Jack Smith's 2 criminal indictments, again, all in 2024. One trial in Washington, D.C. for January 6th, the other in Florida for withholding classified materials. John Bolton just pled guilty for far less, and he has to pay $2 million, and he's facing 5 years in prison. Now, both of Jack Smith's indictments ended up getting dissolved once Trump won in November. Jack Smith, the special counsel, voluntarily shut down his office instead of waiting to be fired by Donald Trump once the convicted felon became president. The classified documents case got tossed out by a Trump-friendly judge, Eileen Cannon, down in Florida. She was appointed by Donald Trump, and she ruled Jack Smith's office was unconstitutional because he wasn't confirmed by the Senate. It's a BS decision. It never would have held up in the Supreme Court once Jack Smith's appeal was heard. All U.S. attorneys, this is the argument, all U.S. attorneys must be confirmed by the Senate, but a special counsel like Jack Smith is appointed by the Attorney General. There's no Senate oversight, no Senate confirmation, and Eileen Cannon got this idea that the special counsel's office was unconstitutional because in his concurring opinion nearly 2 years ago in the Supreme Court's presidential immunity ruling, Clarence Thomas merely raised the question of whether a special counsel's office violates our Constitution's appointments clause because the Senate doesn't confirm a special counsel, and the Senate didn't create the office of a special counsel, which is nested inside the Justice Department. And just from that one question raised by Clarence Thomas in the presidential immunity ruling, Judge Eileen Cannon, the Trump appointee, and she ruled in the classified documents case, she tossed the entire classified documents case out 2 weeks later, citing Justice Thomas's concurring opinion where he just spitballed the idea that maybe we should consider whether or not Jack Smith's office is constitutional. So obviously Jack Smith was going to appeal her ruling, but he dissolved his office right after Trump won. He should have continued and forced Trump to fire him the way Archibald Cox forced Nixon to fire him, the way Elliot Richardson forced Nixon to fire him. Jack Smith didn't. And that speaks volumes to how Merrick Garland, Joe Biden's attorney general, slow-walked the prosecution of Donald Trump. January 6th happened in 2021. I believe it happened, I better double check here, but I think it happened on January 6th. And last time I checked the calendar, that's the beginning of the year. They had all of 2021 to prosecute Donald Trump for January 6th. The Senate trial, the impeachment trial, took place a little more than a month later. I think the Senate trial was February 13th or something like that. He was impeached by Congress a week later, and then the Senate trial, which took place during the Biden administration, they were able to mount a prosecution of Donald Trump in the Senate Took 5 weeks. Took Merrick Garland and Jack Smith 2.5 effing years to indict Trump for January 6th. And by the time Donald Trump was indicted, Trump was already running for president again. So it gave him license to call those indictments political trials. Had he been indicted in 2021, like we would have been, or the other January 6ers had been, this whole thing would have been resolved by 2024 instead of just getting started. But that was all in 2024. Nevertheless, it should have been in 2021. 2024, not a great year for Donald Trump. He lost 1 criminal plus 2 civil trials. 3 other criminal trials got tossed out only because he won the presidency. Not a great year for Donald Trump, 2024, other than winning the presidential election, which has kept him out of court, but partly because of Monday's ruling by the Supreme Court, he's temporarily out of court. Temporarily. If he ever leaves the White House, every year for the rest of his life will be 2024 without the big win in November to absolve him. He knows this. He knows that. It's why the entire Department of Justice now is made up of his former defense lawyers. The upshot of the court's decision on Monday not to hear the E. Jean Carroll case is, once Donald Trump is no longer president, it means he can be sued for civil damages over anything he said or did during the interim period between presidencies. Now, we know, everybody knows, constitutionally and legally, he can be, but with this Supreme Court, you're never certain. Today, Monday, the Supreme Court, by refusing to hear the E. Jean Carroll trial, let every trial lawyer in America know you're free to sue Donald Trump for damages, for any liability caused, for any damages caused during the Biden administration when he was not president. Now, there are 2 verdicts that E. Jean Carroll won. There's the $5 million verdict. That was decided on Monday. She's going to get $5 million. He has no other options but to pay. And then there's the $83 million verdict, which with interest, I think is $90 million. I'll get to that in a second. But this was the $5 million verdict. And what is that verdict? It is that Donald Trump sexually assaulted E. Jean Carroll and then defamed her. Can't be appealed, can't be expunged. It's now settled law that Donald Trump, that a civil jury found Donald Trump, a convicted felon, remember the Manhattan hush money trial 2 years ago in May? A civil jury found our president civilly liable for sexual assault. And they also said he defamed E. Jean Carroll in 2022 when he was no longer president. So part of that $5 million verdict is for the sexual assault and the defamation that took place in 2022 when he wasn't president. So this means the courts are saying you can sue Donald Trump in civil court for anything he did during the Biden administration, okay? Again, there are 2 verdicts. The $5 million verdict is for sexual assault and defamation. The defamation is based on what Donald Trump said while he was no longer president. The jury said he was civilly liable for sexually assaulting Agent Carroll in the 1990s and was civilly liable for defaming her in 2022 while he was no longer president during the interim period between the two administrations. The Judge Kaplan, twice put into writing that this jury found Donald Trump civilly liable for rape in common law parlance. Twice, Judge Kaplan, I think Kaplan is a Reagan appointee. Twice he put into writing that had this been another state, he would have been civilly liable for rape, but because New York, at the time of the trial, it no longer does, it differentiates between sexual assault and rape. Agent Carroll claims Donald Trump raped her with a certain type of penetration, which is rape in all 50 states. The jury wasn't willing to go that far. They went with digital penetration, which in some states is rape. Digital penetration at the time of the trial was considered sexual assault. Today, it's rape. That's, if George Stephanopoulos had just said what I said, Disney wouldn't have had to cut a check for $17 million to Donald Trump. But they wanted to cut that check. They didn't care about freedom of speech and the right of reporters. They wanted to pay Donald Trump $20 million to get in his good graces. Okay, clear signal today from this odious Supreme Court that the courts will not protect Trump from any civil lawsuits, probably any criminal prosecutions for anything Donald Trump did during the 4 years he wasn't president. Well, he said he defamed a lot of people during the Biden administration. You can now sue him for defamation. And in fact, you can sue him right now. I'll get to that in a second. Criminal prosecution during the 4 years he wasn't president, there's no question he can be criminally prosecuted, I believe, for wire fraud. I'll get to that in a second. For the crimes he committed during the Biden administration. There are no immunity protections for that. There's a lot going on here right now. But once he leaves office, and I don't know what the statute of limitations are on wire fraud, but raising money while Biden was president, claiming to be investigating voter fraud, raising money on the internet, claiming all your donations will go to proving Joe Biden stole the election, and instead using all that money to pay for Melania's stylist, to pay for your lawyers after all these indictments and civil lawsuits came down. I don't know, but I think that's wire fraud. Bernard Kerik, Rudy Giuliani's henchman, who was police commissioner in New York City under Rudy Giuliani, there are reports that he raised the possibility of wire fraud with special counsel Jack Smith when he was called in to talk about January 6th. Bernard Kerik and Rudy Giuliani were sent by Donald Trump to all the swing states in the lead up to January 6th to prove voter fraud. They went before 61 judges and failed to prove voter fraud. And Trump never paid Bernard Kerik. He never paid Rudy Giuliani. Trump never paid the lawyers who were traveling around the country trying to prove voter fraud. And yet he raised money with the Save America PAC, telling his low information donors all the money is going towards investigating voter fraud. Seems to me it all went to his legal fees, which apparently is legal, but not if you're raising money under false pretenses. I think that is probably wire fraud. And Bernard Carrick raised that, the issue of wire fraud, reportedly, allegedly, with Jack Smith. I have no doubt that had Harris won, Trump would be facing criminal charges of wire fraud. So, again, if Donald Trump said anything defamatory during the 4 years Biden was president, as of Monday, we now know he can be sued in civil court. And this is really important. He can be sued right now. He can be sued right now in civil court for anything defamatory he might have said during the Biden administration. Never forget that in 2019, New York State Attorney General Letitia James took Donald Trump to civil court because sitting presidents can be tried in civil court. And she took Donald Trump to civil court and he settled with her. He kind of admitted to raising money for charity and keeping it. And in his settlement as president during this civil trial that took place during his first presidency, he settled, he agreed to pay back the charities he defrauded and agreed never to host or start a charitable event in the state of New York. That settlement came down in 2019. It was a civil settlement because, according to the Supreme Court, presidents can be sued in civil court for things they did when they weren't president. Donald Trump allegedly or admitted to ripping off charities before he became president, which means Letitia James, New York State Attorney General, sued him while he was president. So you can sue Donald Trump right now in civil court. There's a civil lawsuit going on right now for January 6th, over January 6th. Doesn't stop because he's president. Criminal prosecution stopped because he's president. But civil lawsuits continue while he's president. Where are all these trial lawyers? Why aren't they suing him in civil court right now? The Supreme Court in Clinton versus Paula Jones ruled a sitting president can be sued for something he did before he became president, or in Donald Trump's case, we just got this ruling from the Supreme Court on Monday, or after he becomes president and before he becomes president again. And you can sue him for something he did before he was president or in the years between his presidencies, and that civil lawsuit can go to trial during his presidency. That's what happened to Bill Clinton. He was sued for sexual harassment by Paula Jones. He was the governor of Arkansas. She was a state employee. He invited her up to his hotel room, and I guess he exposed himself, and she sued him for sexual harassment. I think that is also can be considered sexual assault. And he ended up getting deposed for the Paula Jones civil lawsuit while he was president. That lawsuit was allowed by the Supreme Court to continue during his presidency. The Supreme Court ruled Paula Jones' sexual harassment trial could continue through his presidency. The court said even though a president is busy, he's still not too busy to sit for a deposition for a civil trial. This is Fitzgerald versus Kennedy. I think it's a 1982 ruling that was the building block for the Supreme Court's ruling in Paula Jones versus Bill Clinton. Now, that deposition that President Bill Clinton sat for was a trap. The lawyers were working with Kenneth Starr, and they were prompted. Kenneth Starr found out about Monica Lewinsky, and he had nothing on Clinton, so he approached Paula Jones' lawyers, and they were all being paid by the same right-wing cabal. Ken Starr said, while you're deposing Bill Clinton in the Paula Jones civil lawsuit, ask him about Monica Lewinsky during the deposition. And that's where Clinton lied. He said he never had sex with Monica Lewinsky. That was a lie. He lied during a deposition for a sexual harassment lawsuit going on while he was president. And that led to Trump's impeachment. Not Trump's impeachment, Clinton's impeachment. Clinton was impeached because he was set up by Ken Starr in the Paula Jones civil lawsuit. They set him up to lie about Monica Lewinsky. So anyway, Donald Trump can be sued right now in civil court, right now, for anything he said or did during the Biden administration. You can't sue him. In Fitzgerald versus Nixon, 1982, the court ruled you cannot civilly sue a president for anything that president did while they were president. But the courts have made it clear you can sue a former president or a sitting president in court for something they did before they were president, or in Trump's case, during the 4 years he wasn't president during the Biden administration. So the big issue, this is very exciting, the big issue on the table in the E. Jean Carroll trial is the other judgment. This is what you really are going to start hearing about as we head into and after the midterms, and this is why he's never leaving office. A jury also ordered Trump to pay E. Jean Carroll $83.3 million with interest. It's got to be up to 90. And one of those statements, and this is really important, one of the statements the jury held Trump civilly liable for was made back in 2019 while he was president. So we have a big constitutional issue before us that hasn't yet gone to the Supreme Court. And it's all thanks to E. Jean Carroll. Today, Monday, it settled law that Donald Trump can be sued for anything he said or did during the 4 years he wasn't president, during the Biden administration. And now we're going to find out if this Supreme Court is going to uphold Fitzgerald versus Nixon, I think that was 82, and Bill Clinton versus Paula Jones, where they said a sitting president can be sued for something in civil court for something he did while he wasn't president, but we don't know if he can be sued for defamation while he was president, unless you can prove that that defamation was not, did not occur while the president was performing his official role as president. So it's kind of tied to the immunity ruling, where the Supreme Court 2 years ago, I think 2 years ago tomorrow, Supreme Court said a president can only be criminally prosecuted for something he did while he was president if what he did not fall under the shadow of official acts as president. Okay? So, late last year, the U.S. Court of Appeals for the Second Circuit Court ruled that this $83.3 million judgment against Donald Trump that E. Jean Carroll won stands, even though Trump's attorneys argued that what Trump said about E. Jean Carroll in 2019 falls under the scope of presidential immunity. Again, he was president in 2019. The Second Circuit Court ruled, I think it was in September of last year, they said, no, it doesn't fall under the scope of presidential immunity. They ruled a sitting president can, in fact, be sued for defaming a woman who accused that sitting president of raping her because he was not performing an official act as president when he defamed her. And the Second Circuit Court, in their ruling, I think it was in September of last year, cited the Supreme Court's 2024 immunity decision, where the court said nearly 2 years ago today that a former president can be tried in criminal court after they leave office for any crime committed during their presidency if that crime was not committed while performing an official act as president. Again, had Trump lost the election in 2024, Special Counsel Jack Smith was ready. He handed down brand new superseding indictments after the immunity ruling. He handed down superseding indictments, I think like 6 weeks before the November election. And they were indictments for January 6th. Over January 6th, he proved that these indictments, the Supreme Court would accept because the crimes Trump would be tried for were committed while performing unofficial acts as president. Jack Smith was good to go. He had the new indictments. So, what does this mean for Donald Trump? Well, had he lost in 2024, I'm not so sure this Supreme Court would protect him. And I see that today with the E. Jean Carroll ruling. This court, as horrible as it is, protects sitting presidents. Had Trump lost in 2024, this Supreme Court, I want to believe, would no longer be making decisions in the service of the unitary executive theory, which is a belief that the president gets to run the entire executive branch freely with no judicial oversight, basically. And I'm going to get to that a little later on because we have other decisions to talk about. Once Trump was no longer president, I'm not so sure the Supreme Court, even this court, would be interested in protecting him because they wouldn't be protecting the office of the presidency anymore. They would just be protecting Donald Trump. Who knows? Well, this ruling on Monday suggests that this Supreme Court, as odious as it is in the job of making presidents dictators, but not necessarily Donald Trump dictator. This is wishful thinking. We are now beginning to see the building blocks of what lawyers call stare decisis, which is a fancy term for legal precedents. Building blocks. This second judgment against Trump in favor of E. Jean Carroll, the $83.3 million judgment, Second Circuit Court threw out Donald Trump's appeal. Well, it's going to go before the Supreme Court, and this is the big one. This is the big decision to watch for because it's next year, and it's over what Trump said when he was president in 2019. Part of the $83.3 million judgment against Donald Trump was for what Donald Trump said about E. Jean Carroll in 2019 while he was president. Can a president be sued for something he said if it's not falling under the color of official act as president? I have a sneaking suspicion about this court. I do think they're probably going to rule in favor of Trump partly. I think they're going to rule partly in favor of Donald Trump on the $83.3 million judgment. I think they're going to send it back and have the lower court parse out what Trump said about E. Jean Carroll while he was president and what he said about E. Jean Carroll after he was president. And I think they're going to cut the $83.3 million in half and say he cannot be held civilly liable for defamation. Any defamatory statements made while he was president, he cannot be held civilly liable for. I think that's what they're going to rule, not necessarily to protect Trump, but to protect the office of the presidency. I think this Supreme Court would be worried, unitary executive theory, strong president, they're worried that presidents will be sued for defamation over anything they say. So Trump's lawyers have argued that it's a free speech issue, that he should be allowed to defame E. Jean Carroll, because that's what freedom of speech allows him. It doesn't. He also claimed that inciting an insurrection was protected by the First Amendment. It's not. The Second Circuit Court last year rejected Trump's claims that what he said about E. Jean Carroll while he was president back in 2019 he can't be held responsible for in a defamation lawsuit because he's protected under the Federal Employees Liability Reform and Tort Compensation Act of 1988, commonly known as the Westfall Act. It's the Westfall Act, passed in 1988. It shields federal employees from civil lawsuits for anything they do while serving in their official role as a government employee. So if someone wants to sue a federal government employee for something that federal government employee did in their official capacity as a federal employee, the Westfall Act gives that federal employee something resembling qualified immunity. It forces the plaintiff, the person suing, they have to sue the federal government instead of the individual employee. The government is on the hook in a civil lawsuit, not the individual employee. Like if you're audited unfairly by this IRS agent and you want to sue because you think it's discriminatory and you take him to civil court, under the Westfall Act, that IRS agent has a qualified immunity. You have to sue the federal government and they're on the hook for damages, not the IRS agent. Unless you can prove that that IRS agent wasn't working in their official role, in their official capacity as a federal employee. The alleged killer of Renee Good, Jonathan Ross, the ICE agent, has something called qualified immunity, that if the family of Rebecca Good, she was the woman who got shot to death allegedly by Jonathan Ross in January of this year, and as she lay bleeding to death, Jonathan Ross allegedly called her an effing whatever. I'm not going to repeat it. Her family can sue ICE, but not him unless you can prove criminal negligence. And so, by the way, ICE, there was a poll worker who posted the story of Jonathan Ross being identified as the alleged shooter of Renee Good. All she did was take to social media and repost a news article identifying Jonathan Ross as the alleged killer of Renee Good. And last week, an ICE agent visited this woman who was working at a polling station and used the color of the federal government to demand that she take that social media post down, that she was facing charges of doxing an ICE agent by merely reposting a story identifying Jonathan Ross as the alleged shooter, this ICE agent, and he had official documents somewhere from ICE claiming she was guilty of doxing an ICE agent. He entered a polling station where she was working. This is where we're heading. Not legal. Doesn't matter if it's legal. An ICE agent in this climate can say, "Come with me." And as Brett Kavanaugh ruled regarding Kavanaugh stops, eventually you can prove you're in the right. You'll just be detained temporarily. No harm, no foul, according to the very white and entitled Justice Kavanaugh, who has never spent one night in jail, let alone a week or two in a for-profit ICE detention center, which are concentration camps. Okay, back to Donald Trump. And there are other decisions besides this that I have to get to. How am I doing on time here? Okay, so Donald Trump is saying he shouldn't have to pay E. Jean Carroll $83.3 million. The federal government should have to pay it because he's protected under the Westfall Act. Trump's defamatory statements while he was president, according to Trump's lawyers, should be addressed by E. Jean Carroll's lawyers by suing the federal government and not Trump. But the Second Circuit Court ruled last September, I think it was September, that the government cannot defame someone because the government isn't a human being. Well, certainly not one when Donald Trump is president, but they said governments don't defame people. He's not protected under the Westfall Act. Governments are not human beings. Now, the Supreme Court ruled that corporations are. We'll see what they're going to rule. It's going to go through the appeals process all the way up to the Supreme Court. It's the biggie, not because of the $83.3 million price tag, because Trump defamed E. Jean Carroll in 2019 while he was president. Again, I just don't see this Supreme Court allowing a president to be sued for defamation after he leaves office. I don't see them allowing a president to be sued for something they said while they were president, and I think they're going to cut that $83 million in half, and he's going to have to pay damages for what he said during the Biden administration. We have another Supreme Court decision Monday. Again, Trump won 1, lost 3. The court, this is not the one he lost, but it's about defamation. The court refused to hear famed defense attorney Alan Dershowitz's appeal of a lower court throwing out his $300 million lawsuit, defamation lawsuit against CNN. Dershowitz sued CNN, claiming they acted with malice when they misrepresented his statements on what constitutes an impeachable offense, while Dershowitz served as one of Donald Trump's defense lawyers during Trump's first Senate trial. Alan Dershowitz was asking the court to revisit New York Times v. Sullivan. That's the 1964 landmark decision upon which most freedom of speech decisions are based. And I just want to explain what malice means. According to that ruling back in 1964, if you want to sue someone for defamation, you must show malice to win a defamation lawsuit. So if a newspaper prints something that's patently false, you can't sue the newspaper for defamation unless you can prove malice. And legally, the definition of malice is the defendant or the newspaper or the news personality made a statement knowing it was false and acted in total disregard for what the consequences would be when they made those knowingly false statements. That's what malice is. It's different from malice in a personal relationship. It's, in legal terms, it's, you know this is false, but you're saying it anyway. That's the legal definition of malice. Well, like I said, we have a series of Supreme Court rulings handed down on Monday, and we also have some major ones scheduled for Tuesday as our 9 justices go into the home stretch and finish out a term that has been despicable. They gutted the Voting Rights Act. Last week, they gave Trump permission to deport nearly 300,000 Haitians, as well as 1.3 million other people of color. We have another decision today that Trump didn't want. This is another loss for Trump, and it involves mail-in ballots. He's trying to get rid of mail-in ballots. On Monday, in Watson v. Republican National Committee, the Supreme Court ruled that there is nothing in federal law that prevents a state from accepting mail-in ballots postmarked on Election Day. Not only that, and this is a major loss for Donald Trump, the court ruled that if a ballot is postmarked on Election Day, there is no federal law preventing those ballots from being counted as they come in, even if they arrive several days after the election. In other words, if you mail in your ballot on Election Day and it's stamped Election Day, right? Doesn't matter how long it takes for that ballot to arrive. By merely dropping it into the post office box and getting it stamped that day, that is tantamount to casting your ballot unless a state rules otherwise. In other words, there's no federal law that forbids states from treating mailboxes as polling booths, essentially. The state of Mississippi allows voters to drop their ballots in the mailbox on Election Day. And according to Mississippi law, if that ballot arrives within 5 days, it must be counted. And the Supreme Court held up that law, which was being challenged by the Republican National Committee serving as Trump's surrogates. They sued the state of Mississippi, claiming this law violated federal election law. The Supreme Court ruled it didn't. This is why today, after the ruling, you heard Trump screaming for passage of the SAVE Act, which is all about preventing undocumented Americans from voting and pretty much making mail-in ballots impossible to cast. What this ruling on Monday implies is elections, and this is really important, elections are not decided on Election Day. The Supreme Court acknowledged that it takes days, sometimes weeks, to count all the ballots, something Trump insists should not be allowed. You hear him complaining about California. He's sending out prosecutors to look into why it took so long to count the primary votes. They're claiming Spencer Pratt was cheated because it took so long to count ballots. Well, California takes elections very seriously, and they go over the ballots with a fine-tooth comb. Is that what it's called, a tooth comb? They go over, they make sure they want to count the ballots correctly, so they take their time. But Republicans don't like this because traditionally, although it's changing, traditionally Republicans show up to vote in person on Election Day. And those votes, traditionally, although it's changing, those votes are tallied right away as they come in on Election Day. Mail-in ballots take longer to tally. Most states count their mail-in ballots after the polls have closed, right? So Democrats are more likely to vote using a mail-in ballot. That's after COVID, more and more Republicans began to see the charm of mail-in ballots. But traditionally, more Democrats use mail-in ballots than Republicans, meaning in most presidential elections, Republicans show up at the polls. Their votes are counted first. The Democrats' votes from the mail-in ballots are counted after the polls closed, and this creates the illusion of a red wave. Initially, you look at the numbers and you start believing. That's why, like, Spencer Pratt was in second place in the race for the Democrat in the jungle primary for mayor of Los Angeles. But over time, they started counting the mail-in ballots, and Spencer Pratt fell into third place. This is what Donald Trump does to claim voter fraud, right? In Pennsylvania, back in 2020, when Donald Trump lost, it took a while to count the mail-in ballots. So initially, on Election Day in 2020, it looked like Donald Trump was going to win the state of Pennsylvania. But that's only because the mail-in ballots had not all been counted. Again, Republicans are more likely to show up on Election Day to cast their ballot. Those ballots get counted first. It creates the illusion of a red wave. Then, as the polls begin to close, they begin counting the mail-in ballots, which tend to be heavily Democratic votes, and then you see a surge for Joe Biden, and he claims, it's rigged. They're fixing it. Okay. We have a horrible decision now. This is the one Trump won. It's Trump v. Slaughter, with the Roberts Court ruling in favor of Trump. And again, this is the unitary executive theory in play. This is the Supreme Court fighting hard for a strong president who gets to rule over the entire administrative state without any judicial and sometimes congressional oversight. The Federal Trade Commission, this is the Trump v. Slaughter, which Trump won today. It involves the Federal Trade Commission, or the FTC. It was established in 1914 during the progressive movement when Woodrow Wilson, Democrat, was president. Horrible guy, Woodrow Wilson. But anyway, the FTC was established to crack down on, snake oil salesmen, to prosecute, alongside the Justice Department, people who make false claims about their products, especially when those products can harm you. It's the Federal Trade Commission. For example, Kash Patel, who is now our FBI director, before becoming the top law enforcement official in our nation, Kash Patel was selling an immunity boost, a pill that he claimed removed the COVID vaccine from your system. So he was saying, I know you made a mistake. You got the COVID vaccine. No worries. This is our FBI director telling his listeners or his fans, buy my pill. It removes the vaccine from your bloodstream. Something like that. That was what he was selling. And it is the job of the Federal Trade Commission to prosecute or investigate someone selling a COVID detox pill. So the FTC, the Federal Trade Commission, is supposed to be an independent commission, and the commissioners stagger their terms, each one, so that they're independent. Each one has a 7-year term, meaning they overlap the 4-year terms of a presidency. Commissioners are nominated by the president, and they must be confirmed by the Senate. There are 5 commissioners, and according to statute, according to the law, no more than 3 of those commissioners can be from one political party. The president has the authority to appoint the commissioner of the FTC, but he can't touch any of the other, can't fire any of the 5 commissioners unless there's cause. Well, that's what we thought until this horrible ruling from the Roberts Court. It was always believed since 1914, for more than 100 years, the President of the United States couldn't fire an FTC commissioner unless it was for cause. You had to have done something really horrible for the president to fire you. But last year, Trump fired Rebecca Kelly Slaughter, a Democratic commissioner on the Federal Trade Commission. She had been appointed, I believe, by Joe Biden. I think she was appointed by Joe Biden, right? And he fired her for no reason. So she took it to the Supreme Court. And in a decision written by the Chief Justice, John Roberts, the Supreme Court ruled 6-3 that a president can now, as of today, fire a sitting member of the Federal Trade Commission for whatever reason the president sees fit. For cause removal protections, that's what they're called. In other words, you can't remove me unless you show cause. Those no longer apply to FTC commissioners. John Roberts and the Roberts Court ruling 6-3 that those for cause removal protections are unconstitutional and hinder a president's ability to serve as the chief administrator of the executive branch. Again, unitary executive theory. Strong president. The Roberts Court, however, and I don't think they touched the statute within the establishment of the Federal Trade Commission that mandates no more than 3 commissioners from the same party can serve on the Federal Trade Commission at one time. So I got to double check. There were a couple of rulings that came down, but I'm pretty sure the Roberts Court didn't touch the part of the FTC statute mandating that of the 5 commissioners on the Federal Trade Commission, no more than 3 can represent the same party. That, to me, might be a violation of the First Amendment. That I think might be the constitutional issue. This ruling applies to the Federal Trade Commission, the SEC, the Securities and Exchange Commission, and the FCC. But the court in this decision said it doesn't apply to the Federal Reserve. And Gorsuch, Republican, took aim at Carr, the head of the FCC, warning in his concurring decision that this ruling doesn't give people like Brendan Carr, the chairman of the FCC, to target Jimmy Kimmel. Gorsuch went out of his way in his ruling, a concurrent decision, to scold Brendan Carr, the chairman of the FCC, for threatening to take away ABC's broadcasting license over things that Jimmy Kimmel said. A little ray of sunshine, right? Oh, look speaking of Gorsuch, look up his mother, Ann Burford Gorsuch. She was the EPA administrator during the Reagan administration, and this kind of looks like the Love Canal, which Gorsuch's mother slow-walked the cleanup of. Little history lesson about who Justice Gorsuch is and who his mother is and where he comes from. He comes from a family that believes the love canal, hey, it has the word love in it. How toxic can it be? Well, love can be very toxic. Take it from a man who's been married 5 times. Okay, so the ruling on the FTC, the court went out of its way to say it applies to the SEC and the FCC as well as OPP. Is OPP an agency? No, it's other people's, no. The court said it does not apply to the Federal Reserve. Different type of government institution, and the president can't go in there and fire Lisa Cook yet. We're not sure yet, okay? The court handed down a decision on Monday, and this was a loss for Donald Trump, in Trump v. Cook. The court issued a temporary block on Trump's firing of Federal Reserve Governor Lisa Cook. Why did Trump try to fire Lisa Cook? Well, she's a woman and she's black. She was appointed by Obama, then reappointed by Joe Biden. The court ruling Monday that Lisa Cook can remain on the job as a Federal Reserve governor until her firing by Donald Trump winds its way through the lower courts and presumably comes back up to the Supreme Court like acid reflux. So Lisa Cook, black woman, was targeted for removal from the Federal Reserve by Donald Trump last year. Why? Democrat, woman, black, and she opposes lowering interest rates to the levels Trump wants to artificially inflate the stock market and the housing market. He wants the stock market to go up and the housing market to go up, and you do that by keeping interest rates low. It's why he tried a criminal prosecution against Lisa Cook before he fired her. It's why he tried to criminally prosecute Federal Reserve Chair Jerome Powell over renovations to the Federal Reserve building. So he was trying to criminally prosecute Jerome Powell, chairman of the Federal Reserve, because Powell wouldn't lower interest rates. He didn't approve of Jerome Powell's renovation of the Federal Reserve building, while at the same time, well, have you seen the White House lately? Where's the real crime? Who should be prosecuted for unlawful renovation? So Trump initially tried to prosecute Lisa Cook for mortgage fraud before he fired her, while he was firing her. Our old friend Bill Pulte is now our acting director of national intelligence. He still serves as director of the Federal Housing Finance Agency, so he's got 2 jobs, and he recently became acting director of national intelligence because he dutifully sifted through the mortgages of Trump's enemies in order to make criminal referrals against them under the authority of director of the Federal Housing Finance Agency. He's supposed to be checking mortgages to make sure we don't have a housing bubble. He's in charge of Fannie Mae and Freddie Mac, but instead he's rifling through the mortgages of Trump's enemies and making criminal referrals, and because of that, Trump appointed him to be acting director of national intelligence, which means he's overseeing about 18 spy agencies. Why? Why? To treat classified material the way he treated mortgages. A lot of files on all of us that Bill Pulte is going to get his hands on and then leak. Nobody's going to know that Bill Pulte leaked embarrassing documents from our files. This is going to inform the midterms. You will start seeing garbage coming out starting in September, and nobody's going to know where this crap came from about somebody's sexual peccadillos or sexual crimes. I'm sorry, alleged. Files are alleged crimes. Epstein files are just alleged crimes, evidence, not proof, evidence of crimes. You leak evidence, media can't get enough of it. So this is going to be, we have no idea how lascivious these midterms are going to end up being once Bill Pulte starts leaking files. They're already going after Ruben Gallego. They're already, anyway. So he made Pulte made a criminal referral against Lisa Cook. So far, the Justice Department has been unable to indict her. Trump fired her, but according to the law, it must be for cause. Not because she's a black female Obama-Biden appointee who doesn't want to lower interest rates. Now, with the ruling on the FTC, a president no longer has to show cause if he wants to fire people from the FTC, the SEC, and the FCC. The Supreme Court on Monday saying Federal Reserve may be different. May be different. Let's have Lisa Cook's firing wind its way through the lower courts and bubble up like acid reflux back to the Supreme Court. Trump argued before the Supreme Court that Lisa Cook should be fired because a president should be able to administer his fiscal policy, and that includes influencing the Federal Reserve, but it's Federal Reserve, I think, also set up, what is it, Federal Reserve 1913, also during Woodrow Wilson's presidency, I think. Leave a comment if anybody's still listening. The Federal Reserve is supposed to be independent and not subjected to politics. So you have to, in order to fire a Federal Reserve governor, you have to show cause. So for the time being, the court ruled Lisa Cook stays on the job, and that Trump, for the time being, can't fire anyone at the Federal Reserve. Couple of wins. Actually, one win for Trump on Monday, mostly losses. Big loss is mail-in ballots. How are we doing on time here? Monday, Chaudhry versus United States, a big win for civil libertarians. The court ordering police must get a judicial warrant before geo-tracking someone's cell phone. It's geofencing. You would have to go to Google, for example, and say we need the history of somebody's cell phone location. It's called geofencing. Police try to determine where someone was situated when they placed a call, or just where they were based on cell phone data. The court ruling on Monday that in order to get that geolocation information from a geo-tracking platform like Google, police need a warrant. The court previously ruled the same when it comes to actual cell phone data, as well as GPS data on your car. I mean, your car tells the police exactly, they know exactly where you are. If you're asking your car for directions, They need, for the past 10 years, they've needed a warrant on GPS data, and for about 8 years, a warrant for your cell phone data, and now they need a warrant for your geo-tracking data that Google has a history of because you use Google Maps, stuff like that. Trump lost that issue. Trump doesn't care about. So we have two big decisions coming down tomorrow, Tuesday. John Roberts, I think, pretty much has said Tuesday morning we're going to hear about Trump v. Barbara. That's expected to come down first thing Tuesday morning. And it will offer at least some guidance on the constitutionality of birthright citizenship. This is supposed to be a major loss for Donald Trump. Oral arguments suggested that the judges were skeptical, to say the least, about this executive order that Donald Trump signed last year, which puts into motion steps to get rid of birthright citizenship. It's in the 14th Amendment. 14th Amendment, ratified in 1868. In many ways, the 14th Amendment is the founding document of our nation's rebirth after the Civil War. The 14th Amendment, some argue, is as important as the Constitution itself. And one of the provisions, there's a lot inside the 14th Amendment. Like if you led an insurrection, if you once swore an oath to uphold the Constitution and then led an insurrection, you can't serve elected office. Somehow the Supreme Court in January or February of 2024 said, yeah, but that doesn't apply to Donald Trump. A lot of stuff in the 14th Amendment, including birthright citizenship, meaning it doesn't matter if your parents are immigrants, anyone born on U.S. soil automatically becomes a U.S. citizen. Trump administration argues that this only applied to slaves, right? The 14th Amendment ratified 3 years after the Civil War, and the idea Trump lawyers claim is that birthright citizenship was to make sure that every slave would be considered a citizen based on the fact that most of them were born in America. And the Trump administration arguing it doesn't apply to the children of immigrants, like J.D. Vance's wife. She's, I guess you would call her an anchor baby. Vivek Ramaswamy, the Republican candidate for governor of Ohio, anchor baby. But J.D. Vance wants to get rid of birthright citizenship, as does anchor baby Vivek Ramaswamy. And so last year, Trump signed an executive order that would begin the steps to dismantle birthright citizenship and put an end to anchor babies, which is a serious, I mean, when I wake up every morning and I look at any anchor babies out there? Is that an anchor baby? The court is expected to rule in favor of Barbara, the plaintiff, challenging this executive order. The court is also expected to issue a ruling on transgender athletes competing in female sports. This is the final stretch for the Supreme Court. This is when they hand down their defining decisions. So I'll probably do a show tomorrow. Why didn't I do a show Sunday night at 6:05 p.m.? I overslept. I've kept to my schedule 3 months. I've only missed 2 shows. So this is kind of the makeup show, but Saturday night I went live. I did a bonus episode Saturday night, and I felt guilty that I wasn't doing a show Sunday at 6:05 p.m. Eastern, but I just couldn't get out of bed. But I got up today and I did a show, and maybe I'll do it. Depending on the Supreme Court rulings tomorrow, I'll probably do a show. I'm live every Sunday night, every Tuesday night, every Thursday night at 6:05 p.m. Eastern, come rain or come snow, but maybe not if I oversleep. What do you want from me? I'm miserable. Thank you to Bob and Mila in the chat room. I don't know if you're here. Leave a comment. Go to David Feldman Show. Go to shopdavidfeldman.com and support this show by buying a Scream coffee mug. And there, and this is my big seller. Well, I have the David Ferdman coffee mug, and of course, the Hope You're in the Mood for Diarrhea apron. July 4th is coming up. This is my bit. You'd be amazed at the number of people who debase themselves picking up Hope You're in the Mood for Diarrhea aprons. I have one. They're hysterical. Give it to your mother. She's preparing the big July 4th barbecue, and she's walking around in a Hope You're in the Mood for Diarrhea apron. Big laughs, especially if she doesn't speak English. If she doesn't know she's wearing a Hope You're in the Mood for Diarrhea apron, you know how many laughs you could have at your mother's expense? Well, speaking of that, pick up a Made in Los Estados Unidos coffee mug. Support American manufacturing by picking up a Made in Los Estados Unidos coffee shop. Full disclosure, I have no idea where this cup is made. Don't buy it. I wish I could tell you. You're looking at the epitome of hypocrisy. Okay. I don't know where it's made. When I first printed them, they were made in the United States. Now I have a new company. I don't know where they printed. The Federal Trade Commission should come after me. Well, they would if Donald Trump weren't appointing all the commissioners. I'm David Feldman, reminding you to stay strong and protect the weak. Shut up, David. Just shut up. Just shut up. Just shut your mouth. Shut it.